In the heart of the courtroom, the stakes couldn't be higher. Defendant pleads to stay out of jail after the murder of his brother, but damning evidence threatens to seal his fate until a shocking discovery leaves everyone stunned. And just when you think the tension has peaked, another case takes a
No,
wild
Your Honor,
turn
this is a
as legal
motion to
error sets a
increase his
man free
bail.
moments before he was to be jailed.
We've had
Brace yourself for the unexpected because in this
one
courtroom, nothing is
partial
certain.
hearing as to the decedent, and then this was set on Friday of the week before. And Your Honor granted them time because I was tendering this affidavit and application for search warrant. Before we came back on Monday, Ronald Barnes was killed in a murder. Your Honor granted additional time to the defense for that reason to today's date.
Right, and that's because, of course, the family, of course, was in hopes that they would be able to have a funeral this past Saturday, but the body wasn't released from the medical examiner till, I think, late Wednesday, early Thursday, so the funeral will be this Saturday.
I'm prepared to move forward. I had Ms. Ortega here last week when Your Honor granted them additional time. I'd like to move forward. I appreciate that there's been finally a funeral date as far as that's concerned, but we've been delayed in this process.
Okay, the
If the
motion,
court grants it, it would be.
the motion to increase is, summarize the reason you're asking this. Is this for this December 8th of 2022 matter?
Yeah, there's a bond set on that, Judge, of $100,000. The summation of my seeking the increase is that on October 27th of 24,
A few weeks ago.
Donald Barnes was involved in the same offense that he's accused of, the cause number 23 DCCR 0827. The attached to that is a probable cause affidavit I'm treating as state's exhibits 1. I've additionally on this date tendering state's exhibit 2, which is the affidavit that supports that. I granted that to defense counsel on the Friday that was following. I don't have that date, Judge, just when we did that. But I have that witness who is the author of the affidavit for that search warrant, as well as our probable cause affidavit to present to Your Honor in order to support the motion that we should increase the bails. And the bottom line is that whatever the bond amount was set, which I believe is $100,000, did not prevent this defendant from allegedly committing new offenses.
Fine. Anything you want to add before we conduct a hearing here?
Well, Judge, of course, Judge, like I was saying, I was asking for next Monday in order so my client can attend the services of his twin brother. Unfortunately, we thought that was going to be able to be done last week, but with everything that went on dealing with the medical exam and everything with the funeral home, it wasn't able to be done to this week, Judge. So we are asking for that additional time for that 1 week since we have a confirmed date and everything set.
What about this event in August of just a few weeks ago? I mean, yeah, there's one thing about a family issue concerning a burial, but that kind of steps aside when there is recidivism. He's charged with this first degree felony, serious first degree felony of drug trafficking in a school zone, plus the prior conviction of third degree felony. So he's looking at, in that case, no less than 15, I think, to life imprisonment in that punishment range. But now what we have is an event that I guess I'm going to hear more about just a few weeks ago, where police issue a search warrant where the defendant is, at his home, right?
Yes, sir.
It's at his home. 10 ounces of synthetic marijuana was found in a plastic gallon-sized bag weighing 5.15 ounces. Is another synthetic marijuana found on the table. 3 smaller plastic bags containing plant-like substances, synthetic marijuana.
Your Honor, this location, the 2225 Ives Street that's indicated in this probable cause affidavit is the same location for the underlying offense in cause number 23
Within the
CR.
school zone, right?
Yes, sir. I mean, it's a half a block.
Right. So who do you have here today?
This is Detective Brianna Ortega with Beaumont Police Department.
Raise your right hand. Do you solemnly swear or affirm the testimony and statements you make today will be the truth, the whole truth, and nothing but the truth, so help you God? And for the record, the defendant is present with his attorney, Mr. Lewis. And the problem, Mr. Lewis, is that there's one thing about granting him some time for attending a funeral, but I'm sorry, there's nothing. He has a propensity to be around drug trafficking in school zones. And I'm now worried about children, and there will be. He's his personal issues are important, but yet children are far more important.
Understand that as well, Judge. I do
The
have-
well-being of children are far more important. So go ahead.
Go ahead, state your name for the record.
You have a soft
You
voice.
got to speak up a little more than that.
You know what? Do you want to put her here? Why don't we put her on the witness stand so she has the
Please.
microphone? We can hear better. Thank you.
You need a copy. Of that. Okay, go ahead.
What are you doing? Who are you?
His,
This is his nephew, Judge.
What's he doing?
he was approaching because his lawyer indicated.
I was telling him
Don't
to get his-
approach this bench during a hearing unless you're called forth. My goodness. The rules are the rules. I know y'all don't follow them, but the rules are the rules and they're going to be enforced. Good Lord. Go ahead.
Go ahead and state your name for the record. And who do you currently work for, ma'am? In what capacity? Were you working in that capacity back in December 8th of 22? And weren't you one of the individuals involved with this offense where Donald and Ronald Barnes were both charged with manufacture or delivery of a controlled substance there on that date? Now, for the purposes of this hearing, the one thing I want to ask from the facts of that case is, did that accusation occur at 2225 Ives Street in Beaumont? And that was an accusation back on December 8th of 22. Do you have knowledge as to when that individual actually posted bond, Mr. Barnes? Do you recognize him in the courtroom here today? Can you point to him and identify something that he's wearing? Is he the gentleman that's in the wheelchair? Your Honor, may the record reflect she's identified Donald Barnes.
Yes, it will.
All right, so sometime after that, the case was indicted. Did you continue to receive complaints about drug activity at this location on 2225 Ives Street? Did you continue to investigate whether or not an offense was occurring there? Subsequent to that, did you issue or draft a search warrant to do a different search at this location for basically the same offense? And was that done on August 26th of 24? All right, so I'm gonna show you what I've marked for as State's Exhibit 2. You recognize? You recognize that document? And going to show you on that. Which would be, those are these pre-printed type signatures. Is that your signature? Was that sworn and subscribed on August 26, 24?
Yes,
And was it due to this search warrant that the house was searched there on 2225 Ives on the following date, August 27th, 24?
yes,
Did you do the return that comes there?
yes,
I think that's actually my notes that were handwritten here on that copy. But is that your return as to the items that were found there?
yes, sir.
What was found at that location?
Amount of suspected synthetic marijuana, US currency, a New Haven rifle, cell phone, a prison ID, and mail.
And those things, the cell phone, did you connect it with an individual?
Yes,
Which individual?
Donald.
And is that the same Donald Barnes that we've been talking about here in the courtroom? So as to State's Exhibit 2, does this truly and accurately depict the information that was provided to Judge Wortham in order to get probable cause to search this residence? And we would tender State's Exhibit number 2.
No objection, Judge.
Without objection, it's in there.
According to this search warrant, as well as the probable cause that was filed in this, did we have reason to believe that criminal activity was going on at this location at 2225 Ives? That's here in Jefferson County, Texas, in the city of Beaumont, right? What were you expecting to find at the residence? What did you tell a judge in this application for the search warrant?
Suspected synthetic marijuana, a couple of them, but I also took this one.
And that was based on information you were working with before you sought this application? And did you set that out in detail in the State's Exhibit 2 that we talked about? And did it include specifically this defendant allegedly traffic and narcotics at that location? Now, don't other people live there, don't they? Did you also believe that those individuals may be involved as well?
Yes,
Is one of those his now deceased twin brother Ronald Barnes?
yes,
Is another individual Travante Mouton?
yes,
And a fourth individual by the name of Mark Barnes?
yes.
And is that individual related to Mr. Barnes?
I believe he's a nephew.
Do you know if it was that gentleman that stood up and tried to come to the,
Yes,
so you know who Mark Barnes is?
yes,
So the individual with the yellow shirt in the courtroom, the one that attempted to walk up in the middle of the hearing, that's the other individual that may be involved?
yes.
And to kind of summarize here, within 72 hours before the search warrant, there had been a buy walk operation completed there. That purchase was for synthetic marijuana. That was successfully done. And that was one of the things that you expected. And it was actually one of the items returned,
Yes.
the suspected amount. You can't testify today that that's actually,
No, sir. I haven't had the results yet.
we're waiting on the drug test results for that, right? But in fairness, isn't that what we did with the offense that we currently have on the trial docket in cause number 23 CR 827?
I'm sorry.
What I'm getting at is the facts seem really similar to what we already have on the trial docket. I mean, it's almost exactly similar as to you got an affidavit in that case, you suspected it, the return showed those items. Yes? And it was suspected. I'm sorry.
State's Exhibit 2.
I apologize. I forgot I added an additional copy.
That's okay.
Am I right that they're almost photocopy type
Yes.
cases? So, outside of the obvious here that it seems that Mr. Barnes has continued to traffic in drugs, has there been other accusations at this location to indicate that there's a risk of him being out on bond of continued criminal violations?
Well, the fact that we're still getting complaints after the last search warrant in 2022, I would say yes.
And in fact, is that where his brother was murdered there at that location? What led up to that, to y'all's knowledge?
Oh, about what?
I mean specifically, were there accusations that criminal activity was occurring before that offense date,
But before the December 22 or the August,
the murder?
yes.
Going before that, prior to one of the hearings, did you actually go by the house? And I'm talking about our bond hearings. Didn't you go by the house to see whether or not it appeared like drug activity was going on even before one of our hearings?
Yes, before the search warrant. The most recent.
And in your opinion, was that what was happening? You think we'd be a lot safer if this man's bond was increased? Pass witness.
Go ahead, Mr. Lewis.
Investigator Ortega, now, were you the one primarily doing surveillance or over that operation?
Yes.
And for about how long was this location or did you get?
It's on and off. Like, yeah.
But when you say on and off, is it a day or two on, a week off? How does that work?
It's just,
Case by case.
yes, right.
Okay. Now, as far as this search that happened back in August, now you said there was some suspected drugs found, correct?
Yes.
Was there any field tests or anything done on these substances?
No.
As of right now, we don't know what the substances
They're just suspected.
suspect, right?
Ma'am, say that again, what'd you say?
It's just suspected, right? Drug test.
Okay.
And as far as this weapon, because you talked about that, you in applying for the search warrant, you suspected finding drugs, money, and a weapon.
Yes.
That's correct. And you said that during the search you did find a weapon.
Yes.
Where was this weapon located? Do you know?
That one was located in the northwest bedroom of the house. In the closet.
It was a weapon that was up in the closet. Okay. Just like, was that the weapon in any way you were suspecting to find it?
No.
What type of weapon were you suspecting?
A pistol.
Pistol. Was there any pistol found?
No.
As far as when you do surveillance in this house, you talk about the activity. Is the activity more loitering or people outside around the house, or is it in and out of the house?
Both.
It's both. So at any time you can see people going in and out of the house.
Yes.
Correct. Any particular times of the day?
The times I've watched were just during the day.
So it basically could be people going in and out of the house day and night.
I can just speak to right now. Just because.
To your knowledge, who actually owns that?
I believe it's their parents, but I don't know for sure.
So there was never any investigation to who the actual owners were or
There was
anything?
investigation of who lives there.
Who lives there?
It was, both the Barnes brothers based on their savings sheet IDs and from their own admission that they both live there.
Was there any other information through the investigation where other people may stay there from time to time or for long periods of time?
Yes.
And from your investigation, how many that you can say you've seen there on multiple occasions?
I've been told that, Mark Barnes had stayed there one point in time. And then that, Mr. Moten lived there, maybe not living there, but there a lot.
Okay. And were those the only family members that you know of to normally be at that location?
Also, I believe also some siblings, I don't know their names.
In your investigation, did you, because a lot of the contact you seem to be a lot of family members, did in any type of investigation, did you find out how many family members locally they were or around in the area?
I know that they also have a house a couple streets over, a family member does.
Okay. And then to go in, 'cause I know there's, going to the probable cause affidavit, some issues of, potential tampering with evidence, right? Now, with that, where did that information come
What information?
for the tampering allegation?
So when I went to the house, I saw the suspected synthetic marijuana in the toilet or on top of the toilet seat and around the toilet.
So at that time, you saw the suspected drugs around the toilet or in the toilet. Was there any indication at that point, or did you see any indication that would tell you that whether my client, Mr. Barnes, or even his now deceased brother, at that time, that tried to flush any evidence or anything, or throw anything with him?
Well, it was in the toilet, so I was they were trying to flush it.
But that's the only indication you have that someone was trying, just because the evidence of seeing the suspected.
And the fact that Mr. Donald Barnes took a while to come out of the house and he's on the way out.
About how long did it take from it?
I was saying exactly.
Now, throughout your investigation, did that entail about the condition of Mr. Barnes?
Physical condition? Yes.
And to your knowledge, what is that?
I believe he had a stroke in 2022.
2022, and since that time, he's been confined to a wheelchair. Is that correct?
Yes.
Okay. So, given that, would you suspect that it would take him longer than a normal able-bodied person to come out of the house?
It might take.
Might take longer, right?
Anything else?
Nothing more for this one, Mr. Judge.
Okay.
I have no additional
All
questions,
right,
Judge.
I've got just one point to clarify. The drugs that we're talking about, the suspected drugs that we're talking about here, based upon the search warrant that occurred a few weeks ago. We don't know what those are.
We don't know.
Is that right?
Not yet. No, sir.
All right, what do you want?
Well, Judge, I'm asking if the bond stay as it is.
It will. Until those drugs are certain, not just we believe it might be, we don't have anything to go on. That's it. All right. Let me know if things change.
It will be excused, Judge.
Yes.
Step out.
All right. Do we have some dispositions, John?
Yes, sir.
Come on up. Who is it?
For Chambers.
Come in front of me.
What about Gloud? Katie Gloud? What was, who's got Gloud in this case? Who's going on that? Katie Gloud.
Mr. Kelly, Your Honor.
Right, that's not the trial docket, Judge.
Okay, I'm just.
Chambliss,
Yeah, go sign.
where's the right hand? Where order?
This one's long out. I was trying
Stuff
to-
shot?
Yes.
Thumb side? There's a flat on the box right there. You have one more time? One more, same one. Yeah, same time. Okay. Flat right there. Okay, stand in front of the judge.
Grounds where? Here,
Trial log on it. This is Mr. Chambliss.
Chambliss, where's his?
It should be in the stack. I think that's all. The last page.
No. Good. How many cases?
Just 1 year, big 1 year.
24 CR 747 is called the state of Texas versus Christopher Chambliss. That's you?
Yes,
Present.
Your Honor.
Present with your attorney, Mr. West, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor, please.
In summary, this indictment alleges that on or about February 14th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault on a public servant. Do you understand what you're charged with?
Yes, sir, Your Honor.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir, Your Honor, I do.
Agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. Is that your understanding of the agreement?
Yes, sir, Your Honor.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir. Your Honor.
How do you plead to this indictment? Guilty or not guilty? Guilty or not guilty?
Guilty.
You're hesitating. Are you guilty or not?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
I was off my medications.
Are you pleading guilty because you are guilty?
Did you do it?
Yes, sir, Your Honor, I did.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did
Yes,
you
sir.
understand it? Discuss it with your attorney? Are the
Yes, sir.
all the contents true and correct?
Yes,
Here.
sir, Your Honor.
State's Exhibit 1 is tendered into it
No objection.
without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. State's
Yes, sir.
Exhibit 1 is made a part of the record for all purposes. Without objection.
Oh, yeah, no objection.
Is pre-sentence report waived?
Please, Your Honor, yes.
How long have you been in jail now? Did you say? A long time? Months?
Since
Weeks? Days? What?
Weeks.
August 15th.
What are the injuries to this lady, please?
She had a bruise, Your Honor. He was there on a detention hold.
What was
and
her damages?
There was no damages.
No physical injuries? It was observed. I
There-
mean, that's.
There was
so
no,
it's physical.
as far as damages, there was no money, that she
No, no.
wasn't treated. She just had some bruising, I believe, on
She was
it.
struck in her face with his hand and let's see. Used his head to strike her in the face. I observed physical injuries. He also spit saliva on her, landing on her neck area, it says. But
No, that's
how
right.
can you hit somebody with your head in the face and, not cause some kind of harm?
Well, there was bruising.
Bruising,
I mean,
I
I don't
understand there's
know.
no, she didn't have any medical bills or anything like that. There's no restitution. There's no restitution, but there was, it
Okay.
did bruise her.
but-
And all that. And like you said a moment ago, Your Honor, one of the big issues was he was there, medical issue and. he was
One of
off
the big
his
issues
medication.
is he competent or not?
Oh, he is confident. Yeah.
And it's not a Then there's no defense there, is there?
No, we're not saying in defense.
Okay,
We're
well
just
then
saying
let's
why.
not waste our time.
Yeah.
Either is responsible or
Yeah,
not.
and he's
But
been in
you hit
contact.
somebody in the face, a woman, and you hit him in the face, which results in this third-degree felony. And they're a public servant, namely a nurse at the hospital, ironically trying to provide medical care to the person he assaults. Okay. That's all. We got a battery running low, which is not a surprise here.
We just have technology issues, it seems like.
How much time does it show? He was in custody. Anything else on this?
I'm sure that's.
I'm going to find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. The state's exhibit 1 admitted here. To find you guilty beyond a reason. I'm going to find you guilty beyond a reasonable doubt. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. You are placed on regular probation for 10 years.
For 40 days, Judge.
There is no fine here. There will be terms and conditions of probation, which are normal and customary for this type of offense. Can you tell me a little bit about what the situation was here
Situation,
with him? Well, yeah, why was he in the hospital?
I believe it was, I don't have my computer right in front of me.
It was an emergency detention hearing, dealing with his, some psychiatric issues, Your Honor, where they had brought him in to the hospital, and that's what they were trying to essentially treat him for on that unit, you know.
Well, I'm concerned about headbutting and striking a nurse.
Yes, sure.
They are they're pretty special people
Yeah.
when it comes to taking care of people, because if they weren't there, who would be? If the doctors need them, so who would be? The point being is, I can put somebody in jail up to 180 days. And when you assault people who are in a position of special providing of public service, then you pay for it on my rights.
Your Honor, if I could respond,
Mhm.
I think he was having issues back then. He's been competent lately. Before he was actually arrested, he and I had been in contact. He had called my office because he knew I was his court appointed attorney while the warrant was pending. He was actually in, was it Alabama? Alabama? He was in another state. Georgia, okay, I knew it was somewhere that way. He was in Georgia, whatever. Me and him were coordinating back and forth, trying to get him, figure out what's going on in the case. He's been competent. He's never denied doing this. He's always been very,
And he's charged with,
Yeah,
I'm sorry, intentionally, knowingly, or recklessly causing
yes,
bodily
and,
injury.
and
So
he
it's,
understands that.
he's accepting
He's
responsibility.
absolutely, Your Honor.
But you don't assault somebody, especially hit a woman in the face of a nurse and sashay out of here without paying a price.
Well, and another thing, Your Honor, he's currently expecting his first child. When is it due?
I'm more worried about you know what I'm worried about is the victim,
I
the
understand. Your Honor.
person who is not paid to be punched in the face
Absolutely, I understand. Your
when they're
Honor.
trying to care.
I
You're going
would
to serve 180 days in jail as a condition of,
I
you
would ask-
served how long? How,
Days so far.
Your Honor, I would ask.
4
the court
months.
to Abate that and see how he does on probation, and if he's messing up, then do it, but I think he's gonna be okay on
Now, if he
probation.
messes up on probation, you're looking at 10 years, but right now you're gonna do 4 months. In 4 more months, you just don't punch a care provider in the face. Sorry. That's
I
just
did,
it.
Your Honor, I did ask her nicely 3 times to back up out of my face. I did ask her nicely. I said, ma'am, please back up out of my face 3 times.
You said what to her?
I said, she was all up in my face and I asked her 3 times. I'm like, ma'am, please back up out of my face. I'm off my meds, really. I was off my meds for like.
So you
4
remember
months.
all of that?
Yes, ma'am. Yes, sir. Yes,
Well,
Your
and just to
Honor, I
be
do.
clear, Your Honor, it was a security officer there at the hospital that
Yeah,
dealing
here's
with
the
him.
deal is, says security officer, it
Yes.
says. Yeah, I want to be. What do you see what this indictment says? I mean, I'm reading the indictment. It says assaulted Linda DeMoss, a public servant, namely a nurse at St. Elizabeth Hospital. Is that wrong or right?
Yes, Your Honor, that's incorrect. It should be the.
Well, the indictment is
security
wrong?
officer. Yes.
We can't be pleading guilty to something that's wrong if everybody knows about it.
Yes, sir.
I didn't realize that. Like I said,
I
I don't,
wouldn't,
have my computer
yeah,
today.
I
I don't have that in front of me like I
Yes, sir.
normally do, Your Honor.
The security guard is also
Still
protected
public, yes, sir.
person,
Yeah,
but
absolutely.
but a nurse is not in a position to be able to defend themselves like a security personnel may be able to.
I do think we maybe need to make an amendment from the,
Yes, Your Honor. Yeah.
I don't think it changes
Y'all-
doesn't change the crime. but it-
Y'all gotta correct this. I mean, I'm heading out in one direction thinking this is a nurse. Nobody's
Yeah.
saying anything until at the end of all of this.
Yes.
And it's the apples and oranges. I made a big speech about protecting the public servant and nurse.
Yeah, it's not. an-
I'm gonna do that because they're trying to help people, not to defend themselves. And security person is in a different position.
Still a public servant. That still falls with that.
So what do y'all want to do in this indictment? This can't be,
Move to amend
this
it, Your
can't be
Honor.
wrong or else we're doing.
Yeah, I
we're
think the
sloppy.
state's movement to amend that, just change nurse to a security officer. And we don't object to that. That's.
Okay, what is the word? Yeah, I'm taking out nurse here at
Yes,
your
Your Honor.
request. And what should it be?
Security
Officer?
Yes, Your Honor.
And then it goes on to say, to wit, in the lawful discharge of an official duty, to wit, or namely providing medical care to the defendant. Well, that's not right either. That security person isn't providing medical care. So what are we doing?
Your Honor-
What do we say for that?
Why don't we do this, since, I'm gonna be back here in the morning. I know Mr.
What do you want to put in here so we can
Do you
move
wanna-
on? So
I think
everybody
the
can move
officer-
on with their life because
Yeah.
I'm gonna follow this agreement as it
Yeah.
is. Just fix it though.
And they were helping.
I'm sorry. It's just, yeah, y'all, an indictment is be accurate.
Then let's give us a little moment to me and Mr. Boyd to work out the actual language we need to get in here, because that's.
They were actually bringing him in the psychiatric area for treatment. It was in that, doing that
So,
and in there.
In lawful discharge of an official duty, to wit, providing security to the hospital.
Yes, sir.
Works. It's up to the state. but-
Well, if it works,
we
is it
did.
right or not?
Yes, Your Honor. We moved to amend.
Or do you swear to God?
Hey,
I mean, we're just,
well,
you had to look
Yes.
at this. You
Yes,
know,
yes.
is that what this person's doing?
yes.
Providing.
Yes, Your Honor.
Security for the
Providing
hospital, yes.
security at the hospital.
Yes, Your
Yeah,
Honor.
that's what this person's on duty for
Okay, all
doing.
All right, corrected. To state, the victim was a public servant providing, a public servant, namely a security officer at St. Elizabeth Hospital in the lawful discharge of an official duty to wit, or namely providing security for the hospital.
That's
Good?
Yes, Your
That's
Honor.
perfect, Your Honor.
All right. And I issued the statement, you're sentenced to 10 years in prison, that is suspended, you were placed on regular probation, there will be terms and provisions that are normal and customary, please see the probation officer. Do you understand? If you fail, your probation could be revoked, you could be sentenced up
Yes,
to
sir.
10 years in prison.
Is the upfront time still part of it, or is that been?
No. No, no. And I don't mean to be light to to a security official,
But it's a little different.
but a nurse is not in a position to defend themselves.
Yes, I
Necessary.
understand that.
And
Yes.
they're like a doctor at a hospital.
Versus security
And
guard,
they're going to
it's
be,
different.
you pay a price. Security, you also pay a price, and he's got a felony conviction now.
Right, exactly. Thank you.